Do you have faith in Ripple's native cryptocurrency, XRP? The latest revelations in the lawsuit are nothing short of a bombshell. This is significant since it will have a direct impact on the suit's outcome. Will XRP restore its strength and begin trading near its all-time highs? Make sure you watch this video all the way through to the finish to learn more about it. There are numerous disagreements surrounding William Hinman's deposition and the missing footage. In this video, William discusses how Bitcoin and Ethereum are not securities. This is the video that Ripple requested from Hinman during the deposition. However, it appears that no one has been able to discover the same. Furthermore, Ripple's attorney claims that the SEC omitted several essential aspects of the deposition. What we have here is a reply video from CNBC, which was published on CNBC's official Twitter account on June 15, 2018. The video discussed Ethereum's likely price trajectory, specifically referencing the SEC statement that Ethereum was not a security. CNBC made no note of Hinman's remarks or referred to the above as Hinman's comments. Rather, the speech was interpreted as a regulatory agency statement rather than Hinman's personal position. This movie demonstrates several important points. First, it places a strong emphasis on Ripple's fair notice defense. Second, the SEC must have been aware of Hinman's statement indicating the SEC position. Since the SEC was aware of the market and public sentiment, the regulator's agency decided to bring an action against Ripple, claiming XRP is a security, implying malice. In the Ripple vs. SEC lawsuit, things have been building up for the SEC. The Daily Hodl published a piece headlined "Did the SEC allow employees to trade XRP?" Ripple files a motion in order to obtain answers. Previously, the fintech firm filed a motion for the U.S. Securities and Exchange Commission to uncover whether it permitted its workers to trade XRP. Employees are obliged by SEC rules to get clearance before trading any securities, but according to Ripple's move, the SEC had not developed such a policy prohibiting its employees from trading digital assets prior to January 2018. In addition, the SEC issued a statement declaring that digital assets could be subject to the current limitation on securities transactions, but it did not identify which assets would be categorized as securities. On Ripple's motion demanding the SEC to provide internal documents, a telephone call was scheduled to resolve the privileges disagreement that had been hanging on since April. Ripple thinks that producing such papers is required to determine whether XRP is a security or not. The SEC, on the other hand, maintained that its internal documents, which included the agency's discussion about the nature of XRP and Ethereum, were protected by deliberative process privilege, despite the fact that Judge Sarah Netburn dismissed the identical case twice, arguing that such papers would be relevant to Ripple's fair notice claim. The SEC raises the same argument again. The defendants previously asserted that the papers would expose the SEC inconsistencies in its decision-making over time, proving that the SEC failed to offer a reasonable warning that XRP may be considered a security. Already, William Hinman's deposition has given the impression that the SEC communications lack regulatory clarity. Two bombshells in the deposition, according to Jeremy Hogan, an attorney close to the XRP community, could strengthen the fair notice defense. According to Hogan, the transcript of the deposition must be at least 500 pages long. However, just roughly 90 pages of the brief were uploaded. The attorney then released two major bombshells regarding the transcript. To begin, the former SEC commissioner indicated that in his initial discussions with XRP representatives, they were attempting to determine XRP compliance in 2020. At the time, the SEC became aware that Ripple's officials were violating the law. Meanwhile, the SEC began its inquiry. Keep in mind, though, that when asked what they might do to comply, his only response, according to his testimony, was to stop selling XRP. According to Hogan, this only helps the SEC from the time Hinman informed the SEC in 2020 until the complaint was filed. It has no impact on fair notice until 2020. Second, regarding the SEC employee prohibition policy, Ripple counsel questioned William Hinman if the securities clearance form would not cover digital assets until 2018, which the former SEC official rejected. As a result, before 2018, the SEC did not consider digital assets to be securities for ethical purposes. On the cross, you never ask a question that you don't already know the answer to. And it bodes favorably for Ripple in terms of its fair notice defense from 2013 to 2018, according to the attorney, returning to the phone call. Despite the SEC's best efforts, the third time seemed to have upset Judge Sarah Netburn a little. As a result, she is even more taken aback when she receives the documents. To put it simply, the phone call was bad for the SEC. Ripple's attorney, Matt Solomon, argued that the DPP failed to defend the SEC non-disclosure. Tenorero, the SEC counsel, then stated that granting access to internal records relating to the SEC discussion of digital assets would be exceedingly damaging, prompting the judge to ask what harm the SEC anticipated it would cause. As the SEC attorney resorted to convoluted legalese, an irate Netburn responded by doing a personal on-camera review of the documents to determine if the DPP argument held up in the face of the document's significant relevance to the case. The call was terminated by Judge Netburn. The judge will analyze the SEC internal documents on her rule, following which she will decide whether such records are protected under the SEC deliberative process privilege claim. The said judgment is slated to be made after September 28, 2021. After the public became aware of the situation, Ripple Labs CEO Brad Garlinghouse took to Twitter to address the current public perception of the situation, which had expanded from being about XRP securities classification to a larger case involving major governmental institutions, the fair notice defense under the United States Constitution, and, most importantly, the entire cryptocurrency market. Following Brad's tweet, several additional Twitter users addressed the issue. The current scenario is tense, and the SEC prospects are bleak. However, the SEC cannot bear the full load. The court has ordered Ripple to provide over terabytes of Slack messages. The SEC has previously complained about Ripple's data inaccuracy and failure to release most papers. Despite Ripple's protest that it was disproportionate and unjust, the judge dismissed it. The entire scenario has become entangled in a position in which the SEC is under tremendous pressure. Ripple is under the similar pressure, especially when it comes to producing all of its Slack messages. However, the pressure is greater on the SEC side because internal records have a considerably higher value, and a single discovery could be the determining factor in the litigation. The controversies in this case are significant, as the outcome of this suit will tell us about the future of cryptocurrencies, particularly the SEC market supervision. Because this case is of great public importance, any new information must be handled with caution. XRP, which was established to replace the outdated monetary transfer system, is now going from court to court to prove its locus standi on its existence. However, it appears that the general public supports the fintech firm. From a technical standpoint, XRP is performing admirably, which is unthinkable for a coin whose trade has been stopped on numerous platforms. XRP is currently trading at $1.31, representing a 4.50% increase in the last 24 hours. XRP has successfully bounced over its first and second barriers of $1.9 and $1.27, establishing a fresh uptrend powered by 36% rise to the third hurdle of $1.70. Given the strong buying interest in the cryptocurrency, XRP is projected to surge to its 3-month high of $1.96. The token's trendline appears to be in a positive wedge that is properly heading upwards. Because the developments are already coming to an end, the likelihood of the case being settled before the end of the year is strong. At that point, we would very certainly see XRP reach new all-time highs of $3.31. You should maintain a close check on the token and enter the market at the optimal time to maximize your profits. Please keep in mind that cryptocurrency prices change rapidly, so by the time you see this video, it may have changed to a completely different value. This video's material does not constitute investment advice, financial advice, trading advice, or any other type of advice, and you should not treat it as such. The information in this video is provided solely for educational purposes and should not be construed as financial advice. Before making any investment decisions, complete your own due diligence and talk with your financial advisor. If you want to learn more about XRP, there are 2 more videos on the end screen for you to watch. Please subscribe to our channel and give us a thumbs up. Thank you for viewing. I'll see you in the future video.